For our final project presentation, our group, which consists of myself, Eileen, Kanza, Mocha, and Victoria, will present the topic of company law. This presentation will include 4 parts, which are the definition, the securities regulation, corporate governance, and the insolvency law. The definition of company law is the area of law that deals with business enterprises and are laws relating to the way in which companies are formed, managed, and run. You're going to find yourself dealing with company law if you are a corporate, a limited company, a partnership, or a non-profit organization. And company law includes 3 parts, which are securities regulation, corporate governance, and the insolvency law, which we will further discuss in this.
The first part that we will be talking about is securities regulation. So the aim of securities law is essentially to provide protections to those who decide to invest their money in securities. Securities regulation is also a part of what often is called finance law. For our purposes, finance law can be viewed as made up of 3 parts, which are banking law, and then the regulation of those who conduct investment business and the markets on which investments are traded, and lastly, the regulation of companies whose securities are offered to the public.
Corporate governance. Corporate governance involves a set of relationships between a company's management, its board, its shareholders, and other stakeholders. Corporate governance also provides the structure to which the objectives of the companies are set and the means of attaining those objectives and monitoring performance are determined. Corporate governance means different things to different people in different contexts. The first is a definition laid down in 1992 in the report of the Cadbury Committee, a committee established by the Financial Reporting Council, the London Stock Exchange, and the accountancy profession to consider the financial aspect of corporate governance. According to the Cadbury Committee at paragraph 2.5, corporate governance is the system by which companies are directed and controlled. The second definition is that first provided by the Organization of Economic Cooperation and Development, also known as OECD, in 1999. Corporate governance is identified as one key element in improving economic efficiency and growth, as well as enhancing investor confidence.
Insolvency law. Insolvency is a state of financial distress in which a business or person is unable to pay their bills. It can lead to insolvency proceedings, in which legal action may be taken against the insolvent person or entity, and assets may be liquidated to pay off outstanding debts. Insolvency law is a highly detailed and specialized area of legal practice requiring study of specialist text for a full understanding of its scope and complexity. The 2 key formal processes forming the core of insolvency law are administration, which is a process designed to facilitate the rescue of financially troubled companies, and liquidation, the process by which companies are wound up. During the administration and liquidation processes, administrators and liquidators have various powers, including powers to bring legal actions and to review and challenge the validity of certain transactions entered into by the company. Indonesia's company law. Law number 40 of 2007 regarding limited liability companies regulates how companies operate their corporations in Indonesia. Since the company law was enacted in 2007, it has not been amended, nor were there any new regulations issued in 2015 related to the company law. One noteworthy regulatory development was the enactment of Law number 2 of 2014 regarding notaries. Law number 2 of 2014 made several changes to Law number 30 of 2004 that affect how companies in Indonesia organize and report changes in their corporate organs. The term used to describe the shareholders, board of directors, and board of commissioners.
And for the last part, we will be discussing the changes in Indonesia's company law. Before a notary will sign any notarial deed, such as one that changes the board of directors or board of commissioners or the minutes of a general meeting of shareholders, the notary now requires the authorized signatory not only to sign the relevant notarial deed, but also to provide a fingerprint in the notary's presence. Next, a notarial deed must now be made in the Indonesian language. The deed can also be made in a foreign language if the parties agree, but in that case, the deed must also be translated to Indonesian. Next, there also are changes in how a notary report changes in a company's organization. Previously, any changes to a company had to be reported to the Ministry of Law and Human Rights, or the MOLHR, which would then examine the reported changes and issue a letter. Now, the notary has the responsibility to prepare a report on changes in the company. The MOLHR now only provides the system for reporting changes and prints the letter. It makes no independent examination of the changes. This change to the MOLHR process now requires companies to double-check not only the notarial deed that is signed but also the notary's report and MOLHR letter itself, to ensure that all the information and changes made by the notary are correct and consistent with one another.